Welcome to the Durham Public Schools Employee Training on Seclusion and Restraint of Students. This training is designed to help employees understand the proper use of these techniques and the circumstances under which they may be used in the public schools. Since 2006, North Carolina has had a statute governing the permissible use of physical restraint, mechanical restraint, seclusion, isolation, and aversive procedures with public school students. All of these are techniques or tools for managing student behavior, and it is very important that any employee who may have direct contact with students understand what they are and the legal limitations on using them. We will define each of these terms in more detail as we go along. This law applies to all employees of the Durham Public Schools, not just teachers and administrators, but all other employees as well. It also applies to other persons providing education or related services to students on school grounds or at school events. For example, a speech therapist, an occupational therapist, or a community support worker who's working with students on campus or at a school-sponsored event would also be subject to this law governing seclusion and restraint, even if they're employed by an outside agency. Although these rules do apply to non-school employees, it's important to note that this law does not interfere with the ability of sworn law enforcement officers to use force, including the use of mechanical restraints such as handcuffs or the use of seclusion, in order to carry out their law enforcement duties in the schools. First, we will discuss restraints. What is a restraint? Restraints are used to restrict a student's ability to move. A restraint may only partially limit the student's ability to move, or only limit movement in part of the student's body, such as the arms or legs. This is still considered a restraint, even if the student's entire body is not immobilized. For example, handcuffs, which only restrain movement of the arms, are definitely considered a restraint. There are two types of restraints: physical restraint and mechanical restraint. Physical restraint involves the use of physical force by the school employee to restrict the movement of all or part of a student's body. In other words, when an employee physically uses his or her own body to hold a student or otherwise restrict the student's ability to move, such as by holding the student's arms to his sides or placing the student in a bear hug in order to restrict his movement, that would be considered the use of a physical restraint. A mechanical restraint, on the other hand, involves the use of some mechanism or device, other than the employee's own body, to restrict the student's movement. Specifically, the law defines a mechanical restraint as any device or material attached to or adjacent to a student's body that restricts freedom of movement or normal access to any portion of the student's body, and that the student cannot easily move. For example, handcuffs, straitjackets, seat belts, or safety restraints would be considered mechanical restraints. Now that we have defined our terms, we will discuss the situations in which employees can and cannot use these forms of restraint with students. First and foremost, when can you use a restraint to discipline a student who has misbehaved? The answer is never. Neither physical nor mechanical restraints may ever be used solely to discipline a child. Any use of physical or mechanical restraint solely for discipline would be an unlawful use of force against the student. This includes tying or taping a student's hands or other body parts, holding the student on the floor or against a wall, or any other form of restraint. Now we will discuss the situations in which restraints can be used. In the proper circumstances, restraints can be used with special needs students. Physical restraints may be appropriately used with a special needs student if specifically provided for in the student's IEP 504 plan or Behavior Intervention Plan. Mechanical restraints may be appropriate when used as an assistive technology device for a special needs student, again, as provided for in the IEP 504 plan or behavior intervention plan, or as otherwise prescribed by a medical or other service provider. These plans should contain specific guidelines regarding the purpose of the restraint and the type of situation in which the restraint may be necessary for that particular child. Any employee who will be working with special needs children should take time to familiarize himself with each child's IEP 504 plan and/or behavior intervention plan so that you will know ahead of time the types of restraints that may be used for that child and in what situations the restraint may become necessary. As I just noted, some mechanical restraints can be used appropriately as assistive technology devices for special needs students. An assistive technology device is some sort of equipment or product that is used to help a disabled child increase, maintain, or improve certain capacities or skills. For example, gait trainers, weighted vests, and leg braces are assistive devices that help students with certain disabilities to improve their skills or to function more easily. However, because these devices also restrict the student's movement or a part of the student's body, they can be considered mechanical restraints. This doesn't mean that you can't use any device that restricts a child's movement. It just means that such devices must be used pursuant to an IEP, BIP, 504 plan, or as otherwise prescribed by a healthcare or related service provider. The second situation in which restraint of a student by an employee may be proper is when restraint is reasonably needed for the employee's own self-defense. In order to be considered self-defense, the restraint must involve no more than the amount of force reasonably necessary to protect oneself from harm. This includes ending the restraint as soon as the student no longer poses an immediate threat. For example, if a student is clearly cocking his fist to strike an employee, it would be reasonable for the employee to grab and hold the student's arm, then release it when the impulse to strike out has passed. The use of student restraint in self-defense requires the employee to exercise good judgment and to remember that you are only restraining the child to protect yourself from immediate harm and not to discipline or punish the child for his or her behavior. What if the student has a weapon of some sort? If a student has a weapon or some dangerous object and will not surrender it, an employee can use physical or mechanical restraints, if reasonably necessary, to take the weapon away from the student. Again, the restraint should be proportionate to the situation and last only as long as necessary to take the weapon or dangerous object away from the child and therefore remove the threat. Finally, there is one more set of circumstances when it may be appropriate for an employee to restrain a student, and that is when it is reasonably needed to ensure the safety of others. Just as when the restraint is used for self-defense, restraining a student for the safety of others requires using only the amount of force necessary to protect those who are in danger. For example, if one student is physically attacking another, it is reasonable for an employee to physically restrain that student as necessary to protect those around him from harm. As soon as the situation is under control, the student should be released. So, to recap, there are certain types of circumstances in which an employee may use either physical or mechanical restraints with a child. Both types of restraint can be used when provided for in an IEP 504 plan or BIP for a particular child. In addition, both can be used as reasonably needed for self-defense, to obtain possession of a weapon or dangerous object from a student, and as reasonably needed to ensure the safety of others, whether that be other students, employees, volunteers, or anyone else who is in danger of harm. The important thing to remember is that when dealing with a violent or threatening situation involving a student, the key is to restrain the child only as reasonably necessary to ensure safety, and never to restrain a student out of anger or as punishment. In addition to the situations we've just discussed, there are some additional circumstances in which physical restraint can be used, but mechanical restraint would not be permitted. Remember, physical restraint involves restricting the student's movement using only one's body. For example, if two students are fighting in the hallway, employees may need to physically pull them apart. This would be a permitted use of physical restraint. Physical restraint may also be used to teach a skill, such as teaching someone writing by putting one hand over the student's hand. Physical restraint can also be used to calm or comfort a student, to prevent the student from injuring himself or herself, to escort a student safely from one area to another, or to prevent imminent destruction to property. The law does not permit the use of mechanical restraints in these same situations. So, we have discussed the fact that there are several circumstances in which physical restraint can properly be used with a student, but that the situations in which mechanical restraints are permitted are much more rare. Remember, mechanical restraints involve the use of some device or object, even something as simple as tape or handcuffs, to restrict a student's movement. In general, the use of mechanical restraints is limited to those provided for in the student's IEP, BIP, or 504 plan, those used properly as assistive technology devices, or used in situations where the student has a weapon or otherwise poses an immediate threat of harm to others. The one other situation in which a mechanical restraint is permitted is when using seat belts or other safety restraints to secure the student during transportation. The law governing student restraint does not interfere with the use of seat belts in cars or other vehicles. Now we have covered the proper use of both physical and mechanical restraints. Remember, physical restraints may be used as necessary in several types of situations, but the situations in which mechanical restraint may be used are much more limited. And of course, neither can be used purely for disciplinary purposes. Now we have two new topics to discuss: seclusion and isolation. Seclusion and isolation are also specific behavior management techniques. Although the terms sound similar, the distinction between them is very important. Seclusion occurs when a student is confined alone in an enclosed space, from which the student is either physically prevented from leaving by a lock or other means, or which the student is not capable of leaving due to his or her physical or intellectual limitations. Isolation is also a behavior management technique in which the student is placed alone in an enclosed space. However, when isolation is used, the student is not prevented from leaving, either through physical means or through his own limitations. So, both seclusion and isolation involve placing a student alone in a room or other enclosed space. However, when seclusion is being used, the student is physically unable to leave that space on his own. In contrast, if the student is able to leave on his own, that technique is called isolation. Because when isolation is used, the student is not prevented from leaving, the law does not limit the circumstances under which it can be used. In other words, there may be a variety of reasons why educators might need to isolate a student. The law leaves that decision about whether isolation is required to the judgment of educators. However, there are legal restrictions on where and how a student may be isolated. State law places 4 limitations on an employee's ability to use isolation as a behavior management technique with students. First, the space where a student is placed must be appropriately lighted, ventilated, and heated or cooled. And second, the space must be free of objects that expose the student or others to an unreasonable risk of harm. In other words, the space where a student is placed in isolation must be safe and reasonably comfortable, without objects that the student could use to hurt himself or others. In addition, the length of the isolation must be reasonable in light of its purpose, and the student must be reasonably monitored. What type of monitoring is reasonable will depend on the situation, including the purpose of the isolation and the age and maturity of the student. Now we will discuss seclusion. Remember, seclusion occurs when a student is placed alone in an enclosed space from which he or she cannot leave without help. Like the use of restraint, the use of seclusion is limited by law to very specific situations. These situations are listed in the statute, and we will discuss each in turn. Also, like restraints, seclusion can never be used solely for disciplinary purposes. First, just like restraints, there may be occasions in which the use of seclusion is provided for in a child's IEP, 504 plan, or behavior plan. In that case, school staff may use seclusion as a behavior management technique for that particular child. However, there are still specific legal guidelines that must be followed. When using seclusion pursuant to an IEP, BIP, or 504 plan, school personnel must ensure that, just like an isolation space, the seclusion space is appropriately lighted, ventilated, and heated or cooled, and that the space is free of objects that the student could use to harm himself or others. In addition, if a student is to be placed in seclusion, it can only be in a space that has been specifically approved for such use by the Board of Education. So, unlike isolation, if a student is to be placed in seclusion where he cannot escape without help, it can only be done in certain pre-approved rooms. In addition, the student must be released from seclusion as soon as the behaviors stop, or as specified in the IEP, BIP, or 504 plan. The student must be monitored at all times by an adult in close proximity who can see and hear the student. Therefore, all seclusion areas should have a window, half door, or some other means by which an adult can see and hear what is happening inside. As you can see, the common thread among all of these techniques is that they can always be used as specifically outlined in an IEP, a BIP, or a 504 plan. Beyond the IEP or 504 plan, seclusion may be used in some of the same circumstances for which restraints are permitted, namely as reasonably needed for self-defense and as reasonably needed to handle a student with a weapon or other dangerous object. Obviously, these situations are very rare, but if they do occur, the law recognizes that school employees may need to be able to use seclusion with a student in order to maintain order and safety. In addition, seclusion can also be used as reasonably needed to maintain order in the school environment or to break up a fight, or as reasonably needed in a situation where a student's behavior poses a threat of imminent physical harm to himself or herself or to others, or an imminent threat of substantial destruction of property. Remember, these are two circumstances in which physical restraint is also permitted, but not mechanical restraint. So, of the four techniques we've described today, physical restraint, mechanical restraint, isolation, and seclusion, you can see that mechanical restraint is the most restricted and can be used in the fewest circumstances. The permissible uses of seclusion are also quite limited. Physical restraint is somewhat more frequently appropriate, and isolation is the least restricted by law. So far, we have been using technical terms like seclusion and restraint, which are the terms you would see in the statute or our board policies. But what about the term that every teacher and parent is more familiar with, going to timeout? As you know, a timeout is a behavior management tool in which a child is separated from other children for a limited period of time in a monitored setting. A timeout can happen in the classroom, and it doesn't have to mean that the student is left alone. As long as the student in timeout is not placed alone in an enclosed space, then the law does not limit or restrict the use of timeouts to manage behavior in the school setting. Now we will briefly review one final concept: aversive procedures. We will go through this fairly quickly because the rule is pretty simple to remember. No school employee should ever use aversive procedures on a student. So what is an aversive procedure? An aversive procedure is a systematic physical or sensory intervention program for modifying the behavior of a student with a disability, which causes or can reasonably be expected to cause one or more of the following. Significant physical harm, such as tissue damage, physical illness, or death. Serious, foreseeable long-term psychological impairment. Or obvious repulsion on the part of observers who cannot reconcile the extreme procedures with standard acceptable practice. In other words, when we talk about aversive procedures, we are talking about techniques that are shocking or could cause real physical or psychological damage to a child. These are some examples of disciplinary or behavior management techniques that would be considered aversive procedures. The use of electric shocks, extremely loud or scary noises, forcible introduction of foul substances to a child's mouth, eyes, ears, nose, or skin, putting a child in cold water, physically aggressive acts like slapping, pinching, hitting, etc., blindfolding the child, withholding meals, forcing a child to eat her own vomit, denying access to toilet facilities. These are just some examples of things that would be considered aversive procedures. You can certainly see that the use of these techniques on public school students would be shocking or disturbing to the average person. This list is just by way of example. Other behavior management or discipline techniques may be considered aversive procedures if they could reasonably be expected to cause serious physical or psychological damage to the student. Again, under no circumstances are public school employees permitted to use any aversive procedures on students. It doesn't matter what the student has done, whether the student is disabled or not, or whether someone believes that such a technique could be successful in teaching or managing the student. There are no exceptions to this rule. Aversive procedures are never okay in the public school setting. Finally, all of the procedures we have discussed today, restraint, seclusion, and aversive procedures, bring with them specific notice and reporting requirements that must be followed in certain circumstances following the use of one of these techniques with a student. First, the Board of Education has its own responsibility, namely, to provide a copy of the laws and policies that we've discussed today to you, the school employees, as well as to parents at the beginning of each year. Second, all employees have a legal obligation to make a report to the principal if certain things happen. Specifically, a report to the principal is required any time an aversive procedure is used on a student. As you'll remember, DPS employees should never use aversive procedures with students. Any time that you use an aversive procedure with a student, or witness another employee doing so, you have an obligation to promptly notify the principal. In addition, a report is required any time a mechanical restraint is used for a purpose or in a situation in which mechanical restraints are not allowed. A report is also required any time a physical restraint is used that results in observable physical injury to the student, and any time seclusion is used for a purpose or in a situation in which it is not allowed. Finally, the principal must be promptly notified any time seclusion is used that goes on for longer than 10 minutes or beyond the length of time specified in the student's IEP, 504 plan, or BIP. The principal, or someone else designated by the principal, is then required to alert the parent or guardian whenever he or she receives one of these reports, or whenever the principal has knowledge that one of these events has occurred. In this situation, when the principal has received a report on the use of seclusion, restraint, or aversive procedures, or when the principal has knowledge or notice that one of these events has occurred, then the principal must notify the parents promptly. The principal must also give the parent the name of a specific school employee that he or she can contact for more information about what has happened. So, to review, all employees have a duty to promptly notify the principal anytime an aversive procedure is used, anytime a mechanical restraint or seclusion is used outside of the few allowable situations that we've discussed, anytime physical restraint is used that causes observable injury, and anytime seclusion is used that goes beyond 10 minutes or beyond the time period specified in the IEP. The principal then must promptly notify the parents of what has happened. When I say that both of these notices must be made promptly, that means the same day if at all possible, and by no means later than the end of the next workday. Since we are talking about a legal obligation to notify parents when one of these events occurs, the question arises of whether the notice must be in writing or must take a certain form. The answer is that the first prompt notice that we've talked about, which occurs on the same day of the incident, if at all possible, does not have to take a certain form. In other words, after an incident occurs, the principal or the principal's designee can fulfill the prompt notice requirement by calling the child's parents and verbally explaining what has occurred. However, the school must follow up with a written report of the incident within a reasonable period of time, not to exceed 30 days after the incident has occurred. The school's written incident report must include several details. First, it must specify when and where the incident occurred, and a full description of the incident and any interventions that were implemented. The report should also describe the events that led up to the incident, and it should explain the nature and extent of any injury to the student. Finally, the report should include the name of a school employee whom the parent or guardian can contact regarding the incident involving their child. Finally, while we're discussing the reporting obligations of employees to the principal and of the principal to the parents, I'll say a quick word about retaliation against any employee who makes such a report. Under state law and Durham Public Schools policy, the district and its employees cannot discharge, threaten, or otherwise retaliate against another employee for reporting a prohibited use of restraint, aversive procedures, or seclusion. This is true even if the report turns out to be erroneous. The only exception is if the employee knew or should have known that he or she was making a false report. In that situation, an employee can be disciplined for making a false report. The purpose of the anti-retaliation provision is to ensure that all employees feel comfortable reporting any time they see improper use of seclusion, restraint, or aversive procedures with a child. This concludes our training presentation on seclusion and restraint of students. The purpose of this presentation has been to make all employees familiar with these concepts and the situations in which they can and cannot be used. Remember, physical restraint means using one's own body to restrain all or part of a student's body. Mechanical restraint involves using an object or device to restrain part or all of a student's body. Isolation occurs when a student is placed alone in an enclosed space from which he can leave. And seclusion means the student is placed alone in an enclosed space from which he cannot easily leave. Although these techniques may sometimes be appropriate if called for in the student's IEP or BIP or 504 plan, or under certain other circumstances defined by law, they may never be used for punishment. And aversive procedures, which are behavior management techniques that can result in serious physical or psychological harm, can never be used with a student for any reason. I hope that this presentation has been informative, and I encourage you to refer to board policy and to bring any questions or concerns you have to the Human Resources Department.